Good evening. Thank you for joining us. The Legal Aid Society of Palm Beach County live webinar. Today's topic is avoiding eviction for non-payment of rent, presented by attorney at law Ain Lee Singh. The Legal Aid Society is an organization here in Palm Beach County that provides legal free assistance for folks that are going through difficult times. And we have a variety of programs here at the Legal Aid Society. But it's specifically, this program is going to be featuring this topic by our attorney at law from the Homeless Prevention Program. So welcome today to the webinar. Hello, Ain.
Hi, Mario. Good evening, everyone. All right, so as Mario mentioned, I am a staff attorney attached to the Homeless Legal Prevention Project of Legal Aid Society of Palm Beach County. And very briefly, as the name suggests, the spirit and the goal of the project is to work towards avoiding against persons being displaced and certainly becoming homeless. All right, to do so, we provide advice and counsel, brief legal services, direct court legal representation, and community outreach. As part of outreach today, we are going to answer a number of questions that tenants may have at this time concerning landlord-tenant relationships, and more specifically, eviction for non-payment of rent during the COVID-19 pandemic. Now, this webinar is not meant to be a complete summary of Florida's Chapter 83 Landlord-Tenant Act, nor is it intended for the purpose of providing legal advice. The issues for discussion today include federal, state, and county eviction moratoriums, recent changes in law for eviction due to non-payment of rent, followed by forceful evictions, tenants' rights, rent increases by a landlord and prohibited reasons to do so. We will also provide community and housing resources, and we will end on the eviction court process and proper notice. So topical questions that tenants often have when they call our Homeless Legal Prevention Project hotline is, can my landlord evict me if I do not have enough money for this month's rent? Now, there are protections in place here in Palm Beach County due to a number of moratoriums at the state, county, and federal level. Beginning at the state level, on April 2nd, 2020, Governor Ron DeSantis issued an executive order suspending residential evictions for a 45-day period, and that applies to evictions for non-payment of rent. The deadline for that moratorium is approaching, and that date is May 17th. At the county level, and by county I'm referring to here in Palm Beach County, the chief judge for the county has issued a number of administrative orders suspending the issuing of writs of possession. You may be asking, what are writs of possession? And those are legal documents that authorize a sheriff to go on site and to remove a tenant and their personal property. As you may know, at the federal level, Congress has passed the Coronavirus Aid, Relief, and Economic Security Act, more commonly known as the CARES Act, which prohibits some landlords from filing evictions for non-payment of rent. By some landlords, we are referring to covered properties. And those covered properties include properties that receive federal subsidies, such as HUD housing programs, namely Section 8 Housing Choice Voucher Program, Section 202 Housing for the Elderly, as well as Department of Treasury housing programs, which include low-income housing tax credit properties. Some landlords also refers to housing providers and landlords that have federally backed mortgages. All right, so loans provided by HUD, the Veterans Association, USDA or Fannie Mae or Freddie Mac loans. The moratorium is for a 120-day period. It took effect on March 27th, and it extends until July 25th of 2020. Note, after July 25th, if a landlord seeks to evict, well, before we even get to that, and we hope that we don't get there, after July 25th, a landlord must first give a tenant a 30-day notice to pay or vacate prior to commencing eviction proceedings through the court. So we know what protections the CARE Act affords. So the question then becomes, what does the CARES Act not prohibit? Or to put it differently, what can landlords do during the moratorium? The moratoriums do not prohibit landlords for pursuing evictions that commenced prior to March 27, 2020. Also, they do not prevent landlords from evicting any tenants for reasons other than non-payment of rent. And so there can be evictions for cause, for any non-curable breaches such as destruction, damage, or intentional misuse of the landlord or other tenant's property. There can also be eviction based on the natural expiration of a lease, okay? And so a topical question we're having is persons who have a month-to-month tenancy. In those instances, as long as a landlord gives 15 days notice, they can terminate the lease at this point in time. Now, the moratoriums do not absolve tenants of their legal responsibility to pay rent during the moratorium period. And if you can pay rent, you should pay the rent. Another question tenants may have is, can the landlord evict me without going to court? And the answer to that question is no. Self-help evictions are unlawful, and a landlord has to go through the court process in order to evict a tenant. A landlord cannot forcefully evict a tenant by shutting off the utilities, that is, electricity, water, or gas. Additionally, a landlord may not remove locks, doors, or a tenant's personal property in an effort to make the tenant move prior to eviction, and no doubt prior to receiving a writ of possession from the court. Any landlord who violates the law in this manner may be liable for 3 times the amount of rent. Then there is a question of, is my landlord required to make repairs? Under Florida law, landlords must comply with local housing, health, and building codes. And so a landlord must rent a habitable unit with working plumbing, including hot water, and that is structurally sound, that has working door and window locks. It must be free of pests and rodents. And the landlord must keep common areas clean, sanitary, and free of defects. If you have non-urgent repairs, tell your landlord and give your landlord time to make the repair. In the instance of urgent repairs that pose a threat to your health and your safety, you can ask the landlord to make the repair right away. But I want to caution you, given the coronavirus pandemic, there has been a delay in delivery of goods and services. And so you need to work with your landlord and give your landlord a reasonable opportunity to make the repair or remedy the problem. So what exactly are a tenant's remedy if a landlord fails to make repair? A tenant, I should say, does have the option to withhold rent. If a landlord fails to maintain the structural components, fails to maintain plumbing, or property does not meet code standards. To do so, and I want to emphasize this, a tenant has to give a landlord a 7-day notice calling on the landlord to repair the problem. Now, the problem must be a material non-compliance, such as a rodent or mold infestation. We cannot emphasize enough that the material non-compliance must rise to a certain level that makes the property uninhabitable. And so, by way of example, a broken bulb will not qualify. Please note, Florida law does not give tenants a right to make repairs and deduct the costs from the rent. Nor does a tenant have the right to be reimbursed later by the landlord for any repairs he or she made. If you do want to make the repair yourself, be sure to arrange this with your landlord and get the agreement in writing before spending your own money. So a hot topic question by callers to the project also includes, can my landlord enter my rental unit? A landlord can enter a tenant's unit after providing a reasonable notice. Unreasonable notice means 12 hours under Florida law. But a landlord can only enter at reasonable times, and that is between the hours of 7:30 a.m. to 8 p.m. A landlord may enter at any time without providing a tenant with notice in order to take care of emergencies. And by emergency, this refers to something serious that requires immediate attention, such as leaking gas or a broken pipe. Now, given the coronavirus pandemic, if there is a non-emergency and you do not want your landlord to enter due to concerns, health concerns in particular, you should object in writing with a reasonable explanation for denying access. And where it concerns an emergency, you can ask the landlord to limit access to certain areas required by the repair personnel. Next slide, please. Can my landlord raise my rent now? Is another question often asked. If you currently have a lease in effect, that lease governs. So for example, if you have a year-long tenancy agreement ending on ending on August of 2020, and the lease stipulates that the rent per month is $12.50, then now and up until August, all that you are required is to pay $12.50. The landlord cannot sporadically or just randomly make a demand for increased rent. If you're at the end of a lease or a month-to-month tenancy, keep in mind that a rent increase is still possible. And as mentioned before, with a month-to-month tenancy, a landlord, all that person has to do is give 15 days notice in order to terminate the tenancy. To elaborate, where it concerns a year-long tenancy, a landlord has to give 60 days notice. And in instances of a quarter-to-quarter, well, it doesn't touch on quarter-to-quarter. What I would say is tenants should certainly be guided by any terms and conditions in the lease, okay? And keep in mind that it must be in writing. Now, statements, comments, or threats that the landlord will call ICE if a tenant does not pay rent or does not pay increased rent is discrimination based on national origin. Additionally, if a housing provider seeks to charge you higher rent due to you having the virus, or perhaps you being in close quarters with persons who have the virus, for example, a nurse or someone in the healthcare industry who works with persons who are infected by the virus. If a landlord denies you housing, then that could be discrimination against persons with disabilities. In such an instance, we would invite you to reach out to the Fair Housing Project here at Legal Aid Society. You also have the opportunity to contact the Palm Beach County Office of Equal Opportunity, as well as the Florida Commission on Human Relations. So what if I need help paying my rent or my bills? If you need help paying your rent, you may be able to get temporary help from the county. You can also call 2111 to find out what agencies are providing rental assistance or utility payment assistance. And you can seek to get information on places offering temporary shelter and providing access to food pantries. So the harsh reality is that the moratorium periods will come to an end, as in the case of the executive order put in place by the governor. And so even with the properties that are federally backed and have federal subsidies, it may be the instance where for the months of March, April, May, June, and July, a tenant is not made to pay rent, but it doesn't mean that a tenant is absolved of any and all responsibility to pay rent. The likelihood is at the end of that period, you will get a notice to pay or vacate, and failing to do so, then a landlord or a housing provider is likely to commence eviction proceedings. And so we want to give you an idea of what that may look like. So if you find yourself in that unfortunate circumstance, you have a sense of how to navigate the process and certainly an idea of what to expect. So to begin with, a landlord must terminate the tenancy, the lease, okay? Whether it's a 3-day notice, and to be specific, that would apply to for private properties that don't have any federally backed mortgage loans, okay? Or in the instance of properties that have federally backed mortgage loans or receive federal subsidies, they would have to issue that 30-day notice to pay or vacate. If you don't pay or vacate during that time frame, then the landlord can commence eviction proceedings. And so the tenant will receive a complaint listing the allegations made by the landlord concerning non-payment of rent. The tenant will also receive a summons calling on the tenant to provide a response within a 5-day period. Keep in mind that 5-day period does not include Saturday, Sunday, or a legal holiday. It's very important within that 5-day period that you provide a written answer to the court and you deposit into the court's registry. And I don't say this lightly because it may likely be a sizable amount of money, any of the money that the landlord alleges that you owe. If you are disputing the amount of rent that the landlord claims that you owe, then you must make a motion to determine rent. If you're granted a rent determination hearing by the court, it's usually coupled with a mandatory court mediation, okay? If the parties are unable to settle at the mediation and it proceeds to the rent determination hearing, if it is that the judge agrees that money is owing, know that you may be likely asked to deposit the money into the court's registry on that date or certainly shortly after. After that, there may be a final hearing, and beyond that, a final judgment, or the matter may be dismissed. Where there is a final judgment, all right, the landlord will then ask the court to issue the writ of possession, allowing the sheriff to come on site and to remove you and your personal property if you have not already left. That's typically within a 24-hour period. So we want to focus on what is considered proper notice. All right, now the notice, and I'm using 3-day interchangeably with 30-day notice because it depends on whether it's a private housing provider that does not have a federally backed loan versus a housing provider with a federally backed loan. Regardless, the notice must be delivered to you in writing, and it must contain certain key elements that are identified here. All right. It must state that you did not pay your rent and when it was due. It must indicate the exact amount of rent due. Now, I'm going to stop here for a little bit. Where it concerns rent due for housing providers and landlords with federally backed mortgage loans and subsidies, they are not allowed during the moratorium to charge tenants for late fee charges. All right, so, you know, this is something that you could potentially look out for to see that, you know, that number, any charges are not included in the amount of rent due. It should just focus on the monthly rent specifically. The notice should also include the landlord's name, address, and telephone number, the date the payment is due. The 3-day or 30-day period may not include, as I mentioned, Saturday, Sunday, or legal holiday. And your landlord may hand deliver it to you. The landlord may post it on the door, and yes, that is a valid form of service, or it may be mailed to you. All right. Now, if you receive the notice by mail, the landlord must give you an additional 5-day period to comply with the notice due to mailing time. Now, if you have any questions concerning this, while we are directing you and giving you an overview on what you can do, certainly you can feel free to reach out to us for advice and counsel and representation. At this point in time, I'm going to open up the floor to anyone who may have any questions.
Yes, and we have some questions from the attendees, and I'd like to just ask you this question. Was the administrative order Supreme Court 2023, was it amended to be extended to July 2nd? That's one of the questions.
Okay, so the administrative order from the chief judge, are you referring to the suspension on the issuing of writs of possession?
So the question was it amended to allow an extension to July 2nd?
My understanding is, as it concerns the issuing of writs of possession, it remains in effect, and the deadline date is May 29th of 2020. As far as the July 2nd date that you're referring to, I would not want to mislead anyone, and so I would open it up to perhaps one or two of my colleagues who may have some more insight than I do at this point in time. No? Okay, so.
Okay.
Well,
Here's another question.
We have made a full note of the question, and what we will do is follow up with a response addressing it. All right?
Thank you, Ain. I have another question also from one of the attendees is, how long can an eviction process take? How long is that process?
Okay, so it's a fair question. We cannot give you a set time frame. What I can say to you is you can be guided by the fact that first a landlord has to issue you that notice terminating the tenancy. In the instance of non-payment of rent, it would be that 3-day notice or that 30-day notice, depending on, as we discussed before, whether it's a federal, a property that receives federal subsidies or has a federally backed mortgage loan. Beyond that, once the landlord goes to the court and files the complaint, within days, and again, I hesitate and I'm reluctant to give us a set time frame, but I would say within a week, depending on the form of delivery, whether it is delivered to the tenant by hand or posted to the tenant's door, or it's mailed by the court, that may be another 1 day to maybe 5-day period. All right. And then, so again, so you're starting with either 3 to 30 days, depending on the notice. Then you're looking at maybe 1 to 5 days for receipt of the complaint and summons. And that's followed by a 5-day period. And this is for the tenant to provide an answer to the complaint. Keeping in mind, it may be extended in the instance that a tenant receives the complaint and summons by mail, okay? So you're looking at potentially a 1 to 10-day period. In instances where a tenant does not provides a written response and does not have an affirmative defense, which is a fancy legal way of saying a legal justification for non-payment of rent, okay, such as the property was uninhabitable, or I did in fact pay the rent, and here is proof. Again, if you don't have an affirmative defense and you do not deposit into the court's registry the amount of money that the landlord claims that you owe, when the court reviews your answer, they automatically look into the court's registry to see if there was a payment, and if there's no payment, shortly thereafter, a default judgment can be issued, okay? But in instances where a tenant does have an affirmative defense, explaining why they have not paid the rent, and I want to point out here, unfortunately, a legal justification for non-payment of rent due to loss of employment opportunity caused by the coronavirus pandemic is not a lawful reason, okay? But if you do have a lawful reason and you are able to deposit the money into the court's registry, it could extend to you within a week getting an opportunity for a potential opportunity to settle it. In the instance of you having an affirmative defense and calling and asking the court for a rent determination hearing, that usually follows a week after. And I know I've touched on several different points, but I think you get the impression, you have the understanding that it varies. It could be from 1 day to maybe 2 weeks, 3 weeks. And I also wanna just draw to your attention, given that the courts at the present time are not functioning at the full level, we are likely to expect a backlog once the courts resume at full speed. So, and that may cause a further delay.
Thank you, Ain.
Okay.
And again, I'm
Stop there, and forgive me for doing this so impromptu. One of our colleagues, Amy Petway, who's attached to the Community Economic Development Project and who also handles a number of landlord tenant matters, would like to chime in and perhaps answer that first question. I suspect. Could you perhaps unmute her? So that she can speak?
yes.
But in the interim, I certainly can, answer any other questions as we try to get Amy in on the conversation, because I'm sure that she has more useful information or additional information to share.
We have Melva Rozier on the line. If Melva would like to answer that first question about the extension.
Okay, thank you. And again, Melva also is one of my colleagues attached to the Elder Law Project. Thank you, Melva. All right, so we're having a little technical problem. Can we just see how we can get both Melva and Amy in? And we just ask that you be patient with us, but we certainly want to address that question in full.
Okay, looks like Melva is haven't muted her phone, but I do have another question, Ain, for you from the attendants, from the audience. Here is the question. If you're renewing your lease during the pandemic, is it okay for a landlord to increase your rent?
Okay, that's a good question. Now, if you're renewing the lease, then that suggests to me that the lease has come to an end, perhaps through natural expiration. So for example, it is, it has ended effective April 30th. Once the lease comes to an end and you begin a new lease, understand that the landlord or the housing provider has every right to impose new terms and conditions for the lease, including an increased amount of rent. But certainly the landlord should not put a burdensome amount of rent. The reality is though that there's no rent control restrictions in terms of the amount of rent that a landlord or housing provider can charge. But if based on the question, it implies that it's certainly a huge increase. So if you had a lease and previously you're paying, you usually figure $12.50, and now it's increased by leaps and bounds, and the landlord is now charging you $16.50 or $19.50. It could be made that if you sign a lease to pay that amount, that it is unconscionable. And I would suggest that you reach out to legal aid, and perhaps we can assist you further.
Thank you, Ain. If there are any other questions, please ask Ain at this time. If you have any questions that you would like to ask, you can type those into the chat. We certainly have a few more moments here to answer those questions. Well, okay. Again, thank you everybody for joining today's live webinar. I want to thank Ain Lee Singh, attorney at law at Legal Aid Society of Palm Beach County. And thank you all for joining us for today's webinar. Appreciate it. Stay safe. Have a great evening. Thanks so much. Thank you, Ain.
You're welcome, Mario. I'm seeing a number of